Sued your doctor for medical malpractice, and during the course of your lawsuit, your injuries get worse and worse. When you started your lawsuit, you told the defense, you told the doctor's attorney that your injuries were okay, they weren't that bad. But now, during the course of your lawsuit, your injuries have gotten much worse and you need much more medical care and treatment. Can you now add to your claim because your injuries have gotten worse? You want to know the answer to this question? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer most definitely is yes, you can, and you should, and you will. Go ahead and amend the original injuries that you claimed at the beginning of your case to what your injuries are now. Now, in a medical malpractice case, we have to have a medical expert confirm that the doctor that you treated with was careless and that his carelessness caused you harm and injury. In the papers that are necessary to start your lawsuit, most often we don't go into details about the exact injuries that you suffered. That is saved for a different set of documents that occurs a little bit further down the road. Once your case gets started, and now the defense has answered the allegations in your lawsuit, we are required to go ahead and provide the defense with a list, an itemized list of every single injury you are claiming in your particular case. That document is called a bill of particulars. And in that, we are required to identify exactly what we believe was done wrong to cause you harm and injury and permanent losses. Now, in addition, we are also required to identify what physical injuries you suffered as a result of this doctor's carelessness. And we give a lengthy, detailed recitation of exactly what your injuries are at the time that we're preparing this document. So now, during the course of your lawsuit, you will be questioned in a process known as a deposition. Lawyers also call it an examination before trial. It's really a question and answer session that's given under oath, and in pre-COVID times, this would take place in your attorney's office, in his conference room. During COVID times now, it takes place on a Zoom video call. Your attorney is on the call, you're on the call, the defense attorneys are on the call, and a court stenographer is on the call to record all of the questions you are asked and all of the answers that you give. And the answers that you give represent your sworn testimony, and it carries the same exact weight as if you are testifying at trial, in court, in front of a judge, and in front of a jury. So now let's get back to the question I raised at the beginning of this video. If your injuries are much worse now at the time you are giving your deposition, can you go ahead and tell the defense attorney that your injuries are worse? The answer is yes, you can, and you will, and you must, and you should. Why? Because the defense attorney will give you an opportunity to go ahead and tell him exactly what physical problems you have today, what things you are no longer able to do. And you don't want to hide that information or fail to disclose it, because if in fact your injuries are worse, he needs to know about it. Why? Because it shows the severity of your injuries. It shows how significant your case really is. And now it will put him on notice that he will need to get all of your treating medical records, or at least get updated copies, so that he can learn about these ongoing permanent injuries. So he can learn about all the medical care and treatment you are receiving from the time you started your case up until now, which is clearly significantly more than what you had to begin with. At the end of your deposition, after it is finished, your attorney will go ahead and take that original bill of particulars, which itemized all the injuries that you suffered, and he will supplement it, which means he will add to it. He will now prepare a supplemental document, which basically says, okay, based upon the plaintiff's testimony, we now know, and based upon the records for the medical care and treatment she received, that her injuries are much worse than they originally thought to be. And now, according to her medical care and the doctors that she's seen, she now suffers the following problems. And we will go ahead and itemize every single issue, every single problem that you have talked about, as well as what your doctors have talked about in your medical records. So it is critically important that if your injuries have changed in any significant way, that you tell your attorney about this before your deposition, so he can be aware of it, and he knows that it's important for you to bring this out during the course of your deposition. And importantly, it's critically important for him to go ahead and supplement this document called the Bill of Particulars to put the defense on notice formally that you have now suffered all of these injuries as a result of this doctor's carelessness. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of medical malpractice cases work in the state of New York. You know, in all likelihood, I recognize you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit, but are thinking of doing so, and your matter happened in New York, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.